Hello and welcome. Last time we discussed ways to respond to an alleged Crown agent who was committing sedition by openly denying the validity of the Constitution or parts thereof. This video consists of that reply and may serve as an example of how we can combine parts of the information in the notices with the circumstances of our own case, which process enables us to grow in knowledge and confidence. The main points to note are that we should rebut whatever faulty arguments are attempted, while ramping up the force of our own position and the potential harm that these alleged agents are piling up against themselves for their future trials by jury. So here is the reply to Officer Halfname of the TGA. Dear Officer Halfname, I reply to your letter emailed to me on 27th of June last, which I didn't receive as an email or as spam, but which arrived by registered post on the 11th of July 2022. Your letter, Officer Halfname, indicates a dangerous confusion in your thinking about what is lawful and what is legal. They are two very different things. Laws are precepts to which everyone agrees, as in common law, which has four basic tenets: do no harm, cause no loss, commit no fraud, and keep the peace. There is also constitutional law, which is written by the people, not the government, and binds the latter, not the former. These are laws which apply to everyone, especially government and its agents. They are immutable, like natural laws such as the law of gravity or angular momentum, which exist and have binding power whether people believe in them or not. Natural or constitutional law can only be changed by the will of the people. Contrary to what your statements indicate, constitutional law exists and has binding power. What you're calling laws are acts of Parliament, which are merely pieces of legislation. These are not binding and may be changed by any succeeding Parliament. If a Parliament arrogates to itself the unlawful power to change or overrule common or constitutional law, it not only acts unlawfully but illegally as well. Acts which breach common or constitutional law are in fact high treason, as was explained in the evidence presented to you in my notices. It appears that you either didn't read them thoroughly or failed to understand them. You would be well advised to study those documents properly, Officer Halfname. Do your due diligence. It is an indisputable fact that Article 61 of the 1215 Magna Carta was invoked on the 23rd of March 2001, according to correct constitutional protocols as shown in that evidence. The opinions of judges, lawyers, or professors of law cannot change that fact. The information was publicised. The results are that Queen Elizabeth II was constitutionally deposed on that date, and all alleged officers of the Crown obliged to stand down and consider their oaths. It also means that, as stated in the last sentence of Article 61, which you should have read, that all acts or statutes which purport to limit any of the concessions and liberties granted under this security clause at any time from 1215 onwards are null and void, and shall not be attempted to be enforced either by the monarch or anyone else. That goes double for Acts of Parliament passed since that date, since they obviously cannot have received royal assent in the absence of a constitutional monarch. It is a royal command to join with the entire realm, which in our case means the entire British Commonwealth, under which Constitution Australians all reside, in resisting any such treasonous acts by the Crown or those alleging to be its agents. It was made explicitly clear that I am willing to comply with your demands promptly and in full, upon your providing evidence in substance that Article 61 is no longer in effect, which you have failed to do. Mere gainsaying by a few quoted opinions from unlawfully constituted courts or professors of law does not constitute substantial proof. Authority does not exist automatically. It can only be granted. Therefore, for agents and officers of the Crown to hold the authority granted them by we the people, they must be able to produce the source of their authority when required, which you have failed to do. As things stand at present, the only people who are standing correctly under constitutional law are those who have sworn their oath to uphold the Constitution under the auspices of the Committee of Barons. All others, if they attempt to command other citizens under any pretext whatsoever other than the prevention of crime, which by definition must produce a victim, are behaving unlawfully. You may plead that your actions are legal, but that merely means that they conform to acts or statutes issued by a parliament which is itself unlawfully legislated. The facts are as I stated them. I am lawfully bidden to comply with your orders, and if you attempt further to coerce me, calling it an invitation does not change the basic nature of your action, you will, as will be explained in the accompanying notice, be placing yourself at hazard of both civil and criminal charges of the utmost seriousness. There are no more serious crimes on the statute books than those of treason and misprision of treason, to which you have now added publicly in writing sedition. Please carefully read the following paragraphs. Attention, agents, officers, clerks, signing documentation. Only doing my job. Before you put your own signature or autograph to a document demanding or denying money from or to a private man or woman, or demanding compliance with an unlawful order, ask yourself this. Is there a possibility this private man or woman knows something about commercial liens that I don't? Does my boss delegate this task to me because it gets him or her off the hook? Is he or she going to pay for any claims made against me? Am I insured for any misconduct or damages I may cause a private man or woman? Am I at risk when I sign the company document on a letterhead? Why doesn't my boss or the owner of this company sign these documents? To whom it may concern, to protect you from personal commercial items, why would you put your homes and personal property at risk by signing for your boss? Think about it. Are you just a pawn in the game? Yes, you are if you are signing documents blindly. You have been warned as an act of mercy, because we operate with full commercial liability under penalty of perjury. Do you? Please understand that the 1571 Treason Act, outlining the serious consequences for men and women acting as agents of the Crown, was assented to by a constitutional monarch, meaning that it is still in effect across the entire British Commonwealth realm of which Australia is a part. You would be mistaken to persist in your assertion that quoting invalid and unconstitutional acts give you some protection from the consequences of your actions, Officer Halfname, for it's been established for centuries that actions against common or constitutional law incur severe personal penalties for treason and sedition, which is denying in public, e.g. by writing, the validity of the Constitution or parts thereof. The penalties for sedition include full asset stripping and life in prison. The question is sometimes asked, and is going to be asked many more times soon, who bears the greater responsibility when illegal or unlawful orders are executed? Is it the one giving the orders or the one carrying them out? The answer is clear. It is the one carrying them out. Why is that? Because under constitutional or common law, it is an accepted principle that everyone has a conscience and must take responsibility for their own actions or omissions. That is why the statement, "I was just carrying out orders" or "I was just doing my job" are not a defence when people behave unlawfully. Officer Halfname, do you deny that it is constitutionally enshrined that people are free to do as they please so long as there is no harm, loss, fraud or breaches of the peace occurring in their day-to-day dealings? Legal authority can only exist if there is a lawful authority in place. Therefore, to confiscate someone's property by claiming legal authority without providing proof of claim is an act of violence against the free will of people. Do you, Officer Halfname, deny this as a fact in law? I trust that you are starting to understand the difference between legal and lawful now, Officer Halfname. The legalese system under which you operate may define your actions as legal, but lawful trumps legal, and in the long run it is lawful that counts, because no one is above the law. The fact is that all Australian governments, courts, police forces and government agencies such as the TGA are registered corporations with ABN numbers. As such, they are governed by corporate law, which is contract law. No one may be compelled to deal with any corporation. The TGA has no more lawful authority to compel me to deal with it than does McDonald's to order me to purchase a certain amount of their product. In fact, an attempt to inveigle me into such a relationship, without revealing that the arrangement was in fact contractual, with all the options for declining or negotiating the offer available to me, is a conspiracy to commit fraud, which is a crime under constitutional common law. Do you, Officer Halfname, deny this as a fact in law? When the Queen was petitioned by no less than 68 peers of the realm in February 2001, with the threat that if she continued to break her constitutional oath by allowing Parliament to pass treasonous laws, as listed in the evidence I gave you, Article 61 of the Magna Carta would be invoked. She could have ignored it, or said, as you have, that it was no longer in effect. She did neither, and having sought the most highly qualified constitutional advice available anywhere in the British Commonwealth, she made a nondescript reply to that petition, which did nothing to redress the treason outlined, and resulted in the inevitable triggering of that security clause. She was thus constitutionally deposed until such time as the treason is remedied. Of course, those involved in perpetrating the treason did their best to keep this event quiet, but constitutional law demands that such things be publicised, which the then illegitimate government did as unobtrusively as possible, but still publicly, as the evidence in my notices to you attests. It was no doubt hoped that the general public would remain unaware of these momentous changes, and this was the case for a while. However, truth has a way of coming out, does it not? And now an ever-growing number of people are becoming aware that their whole government system is unlawful and even illegal in many respects. The genie, as they say, is out of the bottle, and it won't be going back in. The day is fast approaching when enough people become aware of the situation that there will be a wholesale reckoning where those who have participated in these crimes, for that is what they are, will be made to stand before courts of common law jurors and must answer for their felonies. Your situation at present, Officer Halfname, is that you have, by your reply, whilst in a state of dishonour to my lawful notices, now added sedition to the crimes of treason, misprision of treason, and theft, which have already been placed in your file for future trial before a jury of people fully conversant with constitutional law. Your best course of action is to immediately cease harassing me in line with my final notice to stop, attached, and immediately return my stolen goods to me or pay the invoice which I included in my last communication with you. I suggest you consult with colleagues senior enough to understand the seriousness of your position and start acting in accordance with constitutional law rather than legalised crime. You have a conscience, and you will eventually be called upon to answer why you aided and abetted the TGA's decision to deny access to life-saving medicine to millions of Australians, which doubtless resulted in the unnecessary deaths of some who might otherwise have survived. unless, of course, you attempt to mitigate your participation by desisting. I note that your letter was accompanied by another of your standard documents informing me that a second consignment of my goods was also seized, and making the same demands as the first such letter. The second consignment was not ordered by me. It was instead sent to me unbidden by my suppliers, who had no obligation to do so, but in doing thus have behaved with great integrity and honesty. My demand that you return my lawfully acquired property extends to this second consignment, for which I shall, upon receipt, acting from conscience, reimburse my suppliers for their integrity, goodwill and costs, and provide proof of having done so to you. Failure to return my goods or remit payment for the same will result in action by commercial lien against you, which will include all my costs for the registered mail, my time at a rate of $1,000 an hour, plus punitive damages for stress and inconvenience caused by your unlawful action, which are not even sustained by the pretense of valid legislation, let alone constitutional law. See attached notice and statement. And signed. Thank you for watching.